Tutorial video on the eviction process, what to expect in court, presented by the Office of the Tenant Advocate. Disclaimer: the information provided in this tutorial video does not and is not intended to constitute legal advice. Instead, all information and content are for general informational purposes only. In the District of Columbia, a tenant may be evicted for one of 10 specific reasons. In order to evict a tenant in the District of Columbia, all landlords must go through the judicial process. All tenants being evicted for a lawful reason in the District of Columbia must receive a written notice with various requirements, including the reason for eviction. Tenants also have the right to 1. Bring the rental account completely current in non-payment of rent cases, 2. Cure or correct the lease violation, and/or 3. Challenge the landlord's claims in court in all eviction cases. In non-payment of rent cases, landlords are required to provide a written notice of past due rent 30 days before filing a claim in court. The written notice does not mean you must leave your rental unit. A written notice is required before a landlord can file to sue for possession of the rental unit. The content and length of the required notice varies based on the type of eviction case. Non-payment of rent cases. If a tenant pays all amounts owed, not including late fees, the eviction process ends here. If 30 days have passed since receiving the notice of past due rent and the tenant still has an outstanding balance, not including late fees, then the landlord may file an eviction complaint in landlord and tenant court. Lease violation cases. If a tenant corrects the lease violation, the eviction process ends here. Note: tenants should notify the landlord that the alleged issue has been corrected. If the notice period has expired and the landlord does not believe the tenant corrected the alleged lease violation, then the landlord may file an eviction complaint in landlord and tenant court. The landlord must serve the tenant with a summons and complaint at least 30 days before the initial hearing date. Tenants may be served via 1. Personal service, where a summons is handed personally to the tenant, 2. Substitute service, where a copy of the summons may be left with a household member over the age of 16, and/or 3. Posting. If the process server has failed service attempts at least twice, the landlord may mail a copy of the summons and complaint and post a copy on the premises in a conspicuous place. However, this method requires time-stamped photographic evidence of a posted summons and complaint at a tenant's address. Please carefully note the date and time of the initial court hearing provided in the summons and complaint, and prepare your records, documents, and evidence for court. If you cannot make it to court on the date provided in the summons, you have 2 options to reschedule. 1. Contact the landlord or their attorney and request a continuance by consent. If the landlord refuses, 2. Contact the landlord and tenant court any day before your scheduled hearing and request a continuance. Note: you must have notified your landlord and/or their attorney in advance to request a continuance. The initial court hearing will be scheduled at least 30 days after the complaint was filed. If the tenant fails to appear at the initial hearing, the court will enter a default judgment in favor of the landlord. So please note the time and date provided in the summons and complaint and prepare your documents and evidence. Initial hearing. For in-person hearings, the court will take roll call promptly at 9 a.m. Be on time. For remote hearings, check your summons for instructions. If a tenant does not appear for the initial hearing, the court will enter a default judgment in favor of the landlord. If the landlord or their attorney do not appear, the court will dismiss the case. Things to remember when preparing for the initial hearing. 1. Courtroom decorum. Be respectful towards the judge, all court employees, and the landlord and/or the landlord's attorney. 2. Prepare your defense. You have a limited amount of time to present your case, so prepare a concise, direct, and informative defense. 3. Bring your evidence. 4. Stay calm and composed. 5. Review the initial hearing video on the District of Columbia Superior Court webpage. Initial hearing. Settlement opportunity. The court will provide the parties with an opportunity to settle, either by a consent judgment, which is a judgment for possession in favor of the landlord that is put on hold, so long as a tenant complies with the agreement, or a settlement agreement, which is a separate agreement between the parties to settle the issue but does not result in a judgment for the landlord. The court must approve any agreement. Initial hearing. If you cannot reach an agreement and settle the case, a tenant in the District of Columbia has the right to a trial to challenge the landlord's claims and tell their side of the story. A tenant may request either a bench or jury trial. Bench trial. A judge will make all decisions at the trial, including whether the landlord or the tenant wins the case. Jury trial. A jury will consider all the evidence and determine whether the landlord or tenant wins the case. If you requested a bench trial, the court will usually schedule the trial within the next 3 weeks. If you requested a jury trial, the court will usually schedule the trial within 3 to 4 months. You will also need to pay a $75 fee, unless the fee is waived, and you will have to file additional documents. Note, there may be pandemic-related delays. Note, before the trial date, you will have to take part in 1. A scheduling conference, 2. Mediation proceedings, and 3. A pretrial conference. Protective order. If a protective order is granted by the court will require the tenant to pay rent into the court registry while the case is pending. The court will hold the money until the case is resolved. Failure to make a protective order payment can have negative effects. For example, if a tenant fails to pay, the tenant risks losing their case. Bell hearing. A bell hearing is an evidentiary hearing to determine the amount of rent that the tenant needs to pay to the court according to the protective order. Tenants can come to an agreement with the landlord on the amount or allow the court to decide. Note, a bell hearing will only occur if there are housing code violations or if the rental amount is in dispute. While you wait for the trial day, prepare your defense, practice your oral argument, and gather and organize all documents, photographs, and supporting evidence. Remember, if you need assistance, call OTA at 202-719-6560. Note, tenants do not have to leave their rental unit while they wait for the court date. Trial. On the day of the trial, bring all of your supporting documents and evidence. Remember, you need to present a persuasive, direct, and concise case. Trial. If the landlord wins at trial and gets a judgment for possession, they can request a writ of restitution that authorizes the landlord to evict the tenant and take back possession of the rental unit. Note, the landlord cannot physically take back possession of the rental unit on their own. All landlords must wait for the U.S. Marshal Service to execute the writ and evict a tenant. If the tenant wins, they do not need to vacate the residential rental unit, and the court must seal the eviction record within 30 days. Please continue to Part 2 of our eviction tutorial, From the Writ to Eviction Day. Or if you have questions or concerns regarding the eviction process, what to expect in court, contact the District of Columbia Office of the Tenant Advocate at 202-719-6560.